Honorable Commissioner of Income Tax Exemptions, this is the most important case law for any charitable trust in the recent history. That is the New Noble Education Society case law versus DCIT. In this case law, before turning into the actual facts, let's understand few sections which would be important for understanding what this case was. For charitable trust, there are two regimes of claiming exemptions. The first regime includes exemption under section 11. Exemption under section 11 is applicable to those trusts that are registered under section 12. And this exemption is based on the amount of application you do. If you do 85% application, then all of your income is exempt. Then second type of exemption is for specific entities like for universities, medical institutions, etc., which are either wholly subsidized by the government or are really small, less than 5 crores. They can claim exemption under section 1023C. But for claiming that exemption, either they need to be registered with the government, be subsidized by the government, or be really small. Our case law specifically relies upon the section 1023C. So let's dive deep into that section to understand. The core requirement of claiming exemption under section 1023C is first, you need to be charitable for any purpose. There shall be no profit or motive in your objectives. Secondly, then you should be solely for a purpose, like solely for educational purpose or solely for medical purpose. There shall not be any other source from where which you derive your income. And the third is approval process, which we will look in the next slide. There are three main sub-clauses under which you can claim exemption under section 1023C. The first one is government funded part. If your trust is substantially financed by the government, that is more than 51%, you can claim exemption under section 1023 3AB. And also, we are looking specifically for educational institutions. Like we are turning from 3AB to 3AD. 3AC is for medical institutions. We are not looking into that because our case law doesn't refer to that. Second is small scale part, where if your receipts are less than 5 CR, automatically all of your income is exempt if you are solely for educational purpose. Thirdly is the approval part. If your receipts are more than 5 crores, you are also not substantially financed by the government. Still you can claim exemption under section 1023C if you are approved by the Honorable Commissioner of Income Tax. Now, let's dive into the case. What was the case? New Noble Education Society. It is So, background of the case. New Noble Education Society was a trust registered in Andhra Pradesh, which worked for promotion of secular education in that state. They applied for registration under section 1023C4. That is the third regime we are talking about. Now, their application to DCIT was rejected. Why? Because DCIT claimed that their objectives along with educational included some non-educational objects like promoting unity among members, employment, upliftment of society, etc. I want to take a time and ask all of you all, are these objectives bad? Can a trust do these objectives? Yes. They are charitable? Yes. Still, the application was rejected. Why? Because they were non-educational. Now, the section 1023C claims that you should be solely for educational purpose. But the past precedents such as Queen's Education Society case law or the American Hotel Association case law tells that the solely word can be interpreted as predominantly or substantially. And they are substantially educational. Still they have some objectives of other than educational, like providing employment, etc. So, taking this fact, they went to the High Court. In the High Court, the question was of the fact that whether the objectives are educational or not. The High Court states that your objectives are not educational and you cannot claim exemption under section 1023C. Now, the question is not of the fact that whether your objectives are educational or not. Question is of the law, that whether the law states that solely means predominantly or exclusively. Hence, taking this question of law, Noble Education Society went to the Supreme Court. Now, Supreme Court had to decide that whether the legislature intended that the word solely shall be interpreted as predominantly or as exclusively. Arguments of the assessee were, firstly, basic argument was interpretation of the word solely. It relied on previous judgments such as Queen's Education Society and American Hotel Association. It claimed that the surplus it generated was not profit and was reinvested next year. And the third was limited scope of inquiry. Now, this is a very tricky subject because there are two types of assessment which a charitable trust goes through. First is the one which when it applies for registration, whether it be 12A or whether it be 1023C. In this, there is a limited scope. Wherein the assessing officer checks genuineness of your trust. And the second assessment is done by the AO, which checks your financial accounts. In Supreme Court, Revenue argued that solely means exclusively. There is no ifs or buts. If you are for educational purpose and educational purpose only, then only you can claim exemption under section 1023C. Predominant object test is invalid in this case because there are objects which are way beyond the educational objective requirement. Now, the Supreme Court's judgment. Supreme Court in its landmark judgment cleared that solely means exclusive. There are no points that you can claim that any other objectives other than education can be claimed as educational. But there comes a problem. There are many cases under section 1023C which are going on before this judgment. There are many cases which can be opened up for previous years than this judgment. Now the assessee did not know that we can't do this, we can't do that before this judgment. So there was specifically a para added that this judgment would be applied prospectively and no case shall be opened before 19th October 2022. Now, the judgment also included that some incidental activities are allowed. Now, what is an incidental activity? If I am running a school, maybe selling my uniform is an incidental activity, selling books is an incidental activity. So who will decide what is an incidental activity and what not? Earlier, this was the vast area of ambiguity, but the Supreme Court in its judgment clearly stated that if you are renting your premises even to other educational institutions for doing the same object, still the same would not be considered as educational and so would be considered as a rental activity and your exemption would be denied. And the other activities like catering, transportation and student-centric supplies would still be considered as your object. Now, looking at all this, we can say that okay, the case was very good and it clearly defined the section. So there shall be no ambiguity after that, right? Actually there is. There are two cases which I want to talk about. Firstly, agricultural university and secondly a medical university. Let's talk about agricultural university. Can any one of you say that we can learn agriculture in classroom? No. We have to go on ground, and when students go on ground, there is some yield. Now, the college has two options: either to let the yield go waste or to sell it. When they sell it, there is sale from the crops, and this agricultural income tends to denial of their exemptions. Secondly, medical college. When you open a medical college, there is a requirement that you should have a super specialty hospital attached to a medical college. Now, when you have a hospital, you generally tend to have a medical store too. So the sale from medical stores shall be included in the books of accounts. So these are some of the cases which are still pending in the courts and have not been cleared till now. So lastly, I want to thank you all for being such a great audience, and I will ask any questions or any points about this.